At the beginning of the semester, when we started talking about contracts, I said that contracts is going to be the basic gist of what we talk about all semester long. It's the backdrop of many of the topics that we discussed throughout the semester, and this is yet another one. Negotiable instruments, and also called commercial paper. I'll actually explain the difference between the two, because there is a difference when you use the term commercial paper versus using the term negotiable instruments. So we have a sales contract. It's been created. It's been executed. The parties are aware of their obligations. You have a party who has performed. The next phase is usually a discussion of payment, and payment can be made one of three ways, either by cash or credit. We just talked about that topic, secured transactions, credit, loans, and some concept called a substitution for cash. Trade is an example. I'll trade you oranges for apples, that sort of thing. But also we use instruments or documents. And that's primarily what we're going to discuss here, negotiable instruments, which is defined as a written document containing the signature of the creator that makes an unconditional promise or order to pay a certain sum of money. And that's going to be done in a specified time or in a demand. And I'm going to break this definition down. We're going to talk about all these concepts, what constitutes a signature, who the creator is, depending on what document it is, what it means of an unconditional promise or order to pay, and specifying a certain amount of money payable in a time frame, i.e. 30 days from now, or on demand right now. So we'll talk about that. Some examples that we've kicked around throughout the semester of an instrument: checks, certificates of deposits, notes. We talked about promissory notes when we talked about the note in the mortgage. And we need to do this. It keeps business flowing, right? If we had to deal with everything in cash, can you imagine, like, business would kind of stop. So that's why we have this, right? Why do we need negotiable paper? What's the purpose? Using cash as a substitute. It's actually always been that way for years, centuries, I should say. You probably read about it in the book. I'm not going to go into the history. But you recognize that agreements could be paid with documents, promise to pay. Documents could be circulated for a substitute for money. So let's talk about how these are used. I want to explain the difference between commercial paper and negotiable instruments. I'll use this example here in a moment, but generically the term for documents that can be exchanged back and forth per contract. I don't even want to use the word contract, because contract actually is a commercial paper. But using the exchange of documents with regards to paying for goods, generally the documents are called commercial paper. It's the Uniform Commercial Code that labeled them negotiable instruments, and it's governed by Article 3 and Article 4 of the UCC. So I had indicated that a contract is commercial paper. How do you give it to another person? We talked about that earlier in the semester. You can assign your rights. That's how in a contract you would do the exchange of your document by assignment. So let me give you this example. So Bob sells a bushel of apples to Nora for $5. In exchange, Nora executes a contract to pay Bob on demand. So that means that when somebody asks for it, she has to pay it on demand. It doesn't say payable 30 days from now. So a few days later, Bob buys some oranges from Pat for $5. Instead of paying Pat cash, Bob assigns to Pat Nora's obligation to pay him $5. When Pat demands the money from Nora, Nora will pay Pat, and everyone will be square. But what happens if there is a problem? What happens if there's a problem? We talked about this when we were discussing contracts and the assignment of rights. So assume now that the apples that Bob sold to Nora are rotten. And Pat demands $5 from Nora. What's Nora going to do? She's going to refuse to pay the $5 because she got rotten apples. So what's Pat's problem? He's not going to get paid for the oranges that he sold to Bob. But as we know from assignment, when you assign your rights in a contract, the assignee, in this case Pat, takes that assignment with any defenses or claims that Nora might have. And in this case, Nora's going to say there's a breach of contract because I got defective apples. So, and Nora is on legal grounds to say that. So what's Pat's recourse? His only recourse is to go back and sue Bob because the commercial paper that he had that was transferred was not accepted. And that's not what we mean when we're talking about negotiable instruments. What's going to make something negotiable, i.e. in Pat being able to get his money, is when he gets the status of somebody called a holder in due course. So, and it's also going to depend on the type of document that he gets. In this example, I gave you a contract, and a contract is commercial paper. It can be transferred. The rights can be assigned. But when you do the assignment, you take the defenses and claims as the assignee that the initial person had. And that's causes problems, as you just saw right now. And we don't want to have those problems. So now we have to talk about negotiable instruments and what kind of resolves those problems. So the law here is under the Uniform Commercial Code, like I said, Article 3. It applies to the transactions involving negotiable instruments. It does distinguish between what's negotiable and non-negotiable. But to the to be negotiable, there's certain requirements that have to be met. And we're going to go through those as to the form and the content of the instrument. So when an instrument is deemed negotiable, it's transferred from one person to another, and that transfer is also governed by Article 3. Article 4, we're not really going to talk about. I have a few things to talk about regarding banks in another video, but we're mainly concerned here with Article 3 when we're talking about negotiable instruments. And whether an instrument is negotiable is going to be determined by looking, like I said, at its form and content on the face of the instrument. So now let's talk about types of instruments. So the types of negotiable instruments, whenever you see NI, I don't want to keep spelling out the word negotiable instruments. It's negotiable instruments, NI. So there's 4 types. The UCC specifies 4 types of negotiable instruments. That is a draft, checks, notes, also called promissory notes, and certificates of deposits, or CDs. Okay? And then those I have lumped. I don't know if the book lumps them this way. I like to lump them this way. I think it makes more sense. We have those negotiable instruments that are called orders to pay, where they specifically say that this is payable. This is ordered to pay. Those are the drafts and the checks. And then there's promises to pay. These, you get a promissory note that says, I promise to pay Mr. X by such and such time for a specific loan. Promissory notes and certificates of deposits are promises to pay. So let's break those. Orders to pay. Draft. What is it? It involves 3 parties. When you see a draft, there's three parties in the instrument. And it's also called a bill of exchange. That's what they call it in England. It's a check or a note without interest. We don't need to know that. I know it's in the book, so I just want to draw attention to it. But we're calling it a draft. And it's an unconditional written order that involves 3 parties. And we have the 3 parties. We have somebody called the drawer, and that's the party creating it. The one who will ultimately sign it. That's the creator. Then we have the drawee, and that's the one who is ordered to pay the money. Usually it's a financial institution or a bank, the drawee. And then the third party is our payee. So the key here is the drawee must be obligated to the drawer, i.e. you have an account with a bank. So it's either by agreement or through a debtor-creditor relationship. That's how you have a relationship with a bank. Debtor-creditor relationship. They have your account. So you have to have the debtor-creditor relationship for the drawee to be obligated to the drawer. And what I mean by obligated to the drawer, to pay, to honor the order. So we have two types of drafts. Actually, I lumped them in the three. I think the book has them in two and then puts the acceptance under one of those. But you have a time draft, you have a sight draft, and I have something here called acceptance. And let's look at this example to kind of point these out here. So a time draft, when you see this document, this is the draft. And you might be going, how is that any different from a check? It looks like a check. And just so you know what you're kind of looking at here, this is actually two drafts. There's an example on the top, and then there's the example with the accepted typed face on it. That's me going to explain what the acceptance is. So there's actually two documents here, not one big document. So the slight difference, draft and a check, is a draft will have a payable out. There's two things: a payable out date, and I'm going to point that out in a second. And a draft is issued by a bank. Even though I told you that the drawee is the one that ultimately signs, our drawee here in this example is the Guarini, Mendoza and Company. They're the ones that have the account at the Morgan Guarantee Trust Company of New York. They're the drawee, Morgan Guarantee Trust Company. Our payee is themselves. So they're paying themselves, which they can do. So this was issued, pre-printed by a bank. You can call up your bank and say, I need a draft. And when this is presented, it is guaranteed. It's guaranteed by the bank to be paid out, because what happens is the bank will hold the money out, will pull it out of your account and hold it. So it's already accounted for when they're presented with this particular draft. Now, the other thing that is unique to a draft, not as a check, is being able to date it on demand or at a later date. So this one is dated April 20th, well, let's say 2019. And it says that it's paid to the order of, and it says sight. So our sight draft is on demand. And it's on demand and payable 90 days after the demand. I'm trying to go a little slow here so you can kind of look for the numbers. So the sight draft, you bring this draft in. Let's say this draft was given to you. You bring the sight draft in. It says on site, payable on site, meaning on demand, when it's presented on payment. And once that is presented to the Morgan Guarantee Trust Company, they will have 90 days to pay you. It says paid to the order of. It's like 90 days after demand. So this is a sight draft. A time draft would be payable at a definite time in the future. It might say 90 days from now. And then the date for your 90 days would be the April 20th, 2019 countdown date. So the distinction between our draft and our check, and we're going to talk about a check in a second, is one, the draft is issued and created, it's created by the bank at the request of the drawer, naming the guarantee trust company as the drawee, and then you have the payee, and in this case, they're paying themselves out of the trust. That's the relationship that they have. They have a trust account. So now the next component here is called the acceptance. So a drawee signs the agreement to pay the draft when it comes due. So this has been accepted. It just adds another guarantee that if this was to be transferred to, let's say, the Mendoza company wanted to transfer it to you for payment, you already know by looking at that document, because it says accepted, that that's going to get paid out, because the bank has already acknowledged that, the trust company has already acknowledged. It's like another assurance for payment. So that's how the acceptance works. The drawee signs the agreement to pay the draft when it comes due, and that is our draft. We'll talk a little bit more about transferring them when we do transfer of the negotiable instruments. So then we have our check. Maybe you're familiar with check, or maybe you're a debit card user, but you got to be familiar with the check. This is a bank check. It's a draft written and signed by a drawer ordering the drawee, which is usually a financial institution, to pay a certain amount of money to the payee. Sometimes we call that person the holder, but the payee on demand. So this is a demand because it's written on that particular date. This is an old check, clearly from 1995. June 10th, 1995. That can be presented at any time that that's handed to the payee. So it's on demand. It's not a date in the future. Can checks be post-dated? Sure, they can be post-dated. They're not usually, they should be honored, but they're not honored. If you're a holder of somebody who has a post-dated check and you walk into the bank before that post-dated, the bank may still accept it. Of course, you run the risk of there not being sufficient funds, because the whole point of having it post-dated is the drawer is saying that's when the funds will be there. But the bank does not have to honor that post date unless the drawee has contacted the bank that says don't accept this particular check until that date it comes due. So you can't just, you can post date it, but that doesn't stop the payee from having to go and present it to the bank unless you notify your bank. And it doesn't negate the check either. So we still have the same folks. We have our drawer and our drawee, and we have our payee, but it's payable on demand. Okay? Different from the draft. The other thing that's different from the draft is this is not guaranteed, right? This is the bank not guaranteeing payment here. With a draft, you're guaranteed payment because the bank is the one creating the document and then pulling the funds aside and holding on to them, and they know that they're there. So this is not guaranteed by a bank. So then the next question is, what's the difference between a bank check, certified check, cashier's check? We have all of these checks. So when a check is certified, we know that the bank guarantees that and will honor the check when it's presented. And again, like the draft, it removes the money from the drawer's account and holds for payment. And the check gets stamped certified, and the payee demands that money from the bank, not from the drawer. It would be on the bank, so that would be guaranteed. Now, how is that different from a draft? The draft is, you can still post-date it, give it a date in the future, right? Due 90 days from now, due 90 days upon demand. So this is what a certified check looks like. You're still going to be the drawer. The drawer is still going to have their signature here. Warbucks International, whoever the agent is for there, will sign. Gotham Trust is going to be the bank that certifies that this $50,000 gets paid. And as you see, you just get a certified check. It can be filled in, made to the order of, or the drawer can decide whose name is going in there. It also could be paid to the order of cash. That's another thing we'll discuss, or bearer. We'll discuss that in a second. I'm just showing you all the different, the checks and the drafts right now that we're negotiable instruments we're dealing with. And our cashier's check, this is signed by the bank. There's no relationship here, and I don't think I pointed it out or made it clear in the bank check, in the certified check, in the draft. The drawer and the drawee have a relationship, debtor-creditor relationship usually, because it's a bank. There's some agreement or relationship between them. This kind of takes it out of it. This is a cashier's check. I can walk into any bank with $2,090 in cash and say, hey, can I get a cashier's check? And I give them the cash. they will make out this check. It's signed by the bank. It's got the bank's name on it, and it's guaranteed because they've been paid. So if I gave this cashier's check made payable to you, you can walk into the U.S. bank, hand it over, and immediately get cash. Or you can walk into any bank or any place you cash your checks because this is guaranteed by the bank. So cashier's check is drawn on the account of the bank itself. It's signed by the bank in return for cash payment. There is no relationship between the drawer or the drawee in this instance. Then we have our promise to pay documents, negotiable instruments. We have our note or our promissory note, and we have our certificate of deposit. So in a note, also called the promissory note, unlike a draft or a check, it's a two-party instrument. It's a written promise by one party to pay another party a specific sum at a definite date or on demand. It's usually on a definite date, but it can be made on demand. Our parties involved is the maker or the promisor, the party who promises to pay. They're the one creating the note or the certificate of deposit. The party the promise is made to is our payee or the promisee. And it's made at a definite time or on demand, with so many days' notice. Dates have to be in these so we know when they become due, and we're going to talk about what's required. An example, like I said, using a note is when we have secured transactions or a note in a mortgage. We have our promise to pay, and in return there's a security agreement executed or a promise to pay, and there's a mortgage executed if you're buying real property. And this is an example of a promissory note. 8 months after the date, February 17, 2013, I promised to pay to the order of Peter Payee $25,000. So 8 months from February 17, 2013, Mike the maker has to pay Peter the payee. So in this instance, we have our maker. I already told you who he was. That's Mike. And we have our payee. That's Peter. This is a two-party instrument. There's no bank involved. And this is what is called it's very similar, a very simple note. Another example may look like this. More of a special form. A lot of notes these days are quite lengthy in pages, but that's a simple, both of those are simple notes that would be valid. You can also have a promissory note or a draft made payable to a bearer or payable to cash, but we'll talk about those two things in a second. Then we have our certificate of deposit. This is a bank note. This is an acknowledgement by a financial institution for receipt of money and a promise to repay it, usually with interest, on a certain date or on demand. Who's the maker of a certificate of deposit? That's going to be the financial institution, and the payee is going to be the customer. So when you bring into a bank to get a CD, sometimes they have dates on them, right? 2 years, 3 years, 5 years, and depending on which one you choose, determines what the interest rate will be. The longer the due date or the demand date, the better the interest rate that you make money on the CDs. So here's kind of a copy of a certificate of deposit. Those things are also transferable. So now, what's the point? That these instruments can be specified using a certain payee. This is important point. Sorry, instruments can have a specific payee, paid to the order of, I promise to pay Rebecca Fox, or it can just say paid to the order of bearer, paid to the order of cash. And we're going to be more specific on language because there are specific language that has to be put in these things to make it negotiable. But what that means when you say bearer, that means the one possessing the document. So anyone can possess it. So what it takes to be a negotiable instrument. All of the following requirements must be on the face of the instrument for it to be a negotiable instrument. Otherwise, it's not a negotiable instrument. And then you have, it's not that it can't transfer, or it's not that it's any good or it's void. You just run into those problems that I said earlier with the apples and the oranges. You become an assignee and you might not get paid. You might have to deal with some defenses or claims that might be made against the document. So this is what it takes to be a negotiable instrument. It has to be in writing, has to be signed by our maker or our drawer, be an unconditional promise or an order to pay. You have to have a stated fixed amount of money, be payable on demand or at a definite time, be payable to the order or to the bearer of, unless it's a check. The big except, it has to have that language, payable to the order of or to the bearer of, except in a check. And I'll tell you why in a little bit when I get down to number 6 more specifically. So a writing, we have to have a writing. The UCC has a very liberal definition of a writing. It could be a printing, could be typewritten, or other intentional reduction to a relatively permanent, tangible form. That's what it has to be, in some sort of relatively permanent, tangible form. The one thing the UCC does not say in the definition, but it's kind of implied, it has to be freely transferable. So it has to be portable. It has to, whatever you reduce it down to in tangible form, it has to be portable. So Susan writes in the sand, I promise to pay $500 to the order of Jack. That's not particularly permanent, right? It has to be reduced to relatively permanent, tangible form. Usually what we're talking about is it's on paper, but what we're trying to get at here in the UCC implies here doesn't necessarily have to be on paper. Example, I write on the side of a barn, I promise to pay $500 to the order of Jack. Would that constitute the writing aspect? Sure it would, but is that particularly portable? Can that be transferable? Easy? Can Jack transfer the side of his barn to his neighbor for the $500 payment? Probably not. So while these two things, yes, are contracts and can be assigned, these won't constitute something that's a negotiable instrument to hopefully get somebody to be deemed that holder in due course. We'll talk about that in a second. Signatures. Got to have the signatures signed by the maker if you're dealing with a note or a CD, or the drawer if you're dealing with a check or a draft. So it has got to have their signature. What if an agent for a drawer signs the check or the note? Is the drawer and the maker liable? Yes. If what? Remember our agent laws? If the agent has the authority to do so, right? So an agent can make the drawer and the maker liable as well, and their signature would be valid. So what constitutes a signature? Any symbol used with intent to authenticate an instrument. So it could be a rubber stamp, it could be somebody's initials, it could be letterhead, that's the intention, assumed names, trade names, anything that would give the idea that it's the intent to authenticate the instrument. And where does it have to be? On the document, anywhere that's on the face of the instrument. It has to be right on the front, right on the face. Can't be on the back. You might be like, well, we signed the back. That is not a signature. That would be an endorsement, and we're going to talk about endorsements and how they affect negotiable instruments. But right now we're talking about that instrument itself. It has to be in writing. Has to have a signature of the maker or the drawer. It also has to include an unconditional promise to pay and an order. Promise or an order. So no conditions. An express promise, the payment can't depend on or be subject to another agreement or event. Okay, if it does, then it's not going to be deemed negotiable. If there's some other occurrence or non-occurrence, it has to that has to happen. So you get a written document from me or from Bob. I owe you $500 and it's signed by Bob. Do we have a unconditional promise to pay? We do not have an unconditional promise to pay. What's an IOU? That you acknowledge that there's some sort of debt, but it doesn't say I promise to pay. It may imply I promise to pay, but it's not an expressed promise. It's just an acknowledgement. So that's what's missing here. You need a promise or an order. It must be expressly written, undertaking, and promise. It must say a promise to pay the debt. So what if on a check the drawer writes for the purchase of textbooks? Does that destroy negotiability? If you write on the check or the note somewhere, it's for the purchase of textbooks. No, this will not destroy the negotiability. And its instrument can refer to or state the purpose for it, or even in the contract, the terms itself. So like a mortgage is mentioned in a note, for the purchase of this property. So you could say what it's for. These aren't conditions, okay? Another one. I promise to pay $500 to the order of Rebecca Fox for the purchase of an iPad Air. That's perfectly valid element of an unconditional promise to pay for purposes of a negotiable instrument. So why only unconditional promises and orders are negotiable? I know I clicked to my next slide. We'll get to the fixed amount in a second. But why only unconditional promises and orders are negotiable? Well, we're using this as a substitute for money, or as a credit device, which would drastically reduce it if it had a conditional promise attached to it, right? So no one would be able to really purchase the instrument without first knowing whether or not that condition was satisfied or not, and it would be very time-consuming and expensive. And nobody would do it. So transferring would be tough. So you need an absolute unconditional promise to pay or order to pay. You also need a fixed amount of money. The negotiable instrument must state with certainty a fixed amount of money to be paid at a time the instrument is payable. And the fixed amount basically it has to be ascertained from the instrument on its face. And that's the amount that's owed. Does that mean we can't say there's interest here? Like let's take this example here. So 8 months from now, months from February 17, 2013, we know that Mike Maker has to pay $25,000. It can be ascertained from the instrument on its face. That's the principal amount. If a note states that $1,000 is due 1 year from October 1st, 2019 at a 14% interest, do we have a fixed amount? And the note says the principal's $1,000, but does the interest mess it up because of any reason? No, because we can determine what that amount's going to be. We can calculate the interest. So the interest doesn't toss it. We need to know what the principal amount is and whether or not we can actually calculate the amount. So a note states that $1,000 is due on demand and bears an interest rate of $14,000. That's fine too. It can be, as long as it can be determined, a fixed amount can be determined. Can you have a variable interest rate? You can. Doesn't destroy negotiability because you'd be relying on different rates of index. But we would be able to determine what that rate is when it becomes due. Then we can make the calculation, as long as we can determine a fixed amount. A note payable in $1,000 cash or its equivalent in gold. This is going to be a problem. It has to be payable in money per the UCC. Instruments payable entirely in money. That has to be. Defines money as the medium of exchange authorized or adopted by a domestic or foreign government as part of its currency. So a note payable in $1,000 cash or its equivalent in gold is not going to be negotiable. Payment in diamonds or 40 hours of service or Facebook stock. Nope, it has to be in cash. There cannot be an equivalent exchange. Amount of money, fixed amount of money. So money only, anything else destroys negotiability. Payable on demand or at a definite time. So it's necessary to know when the maker or the drawee or acceptor is required to pay. So we have payable on demand, or payable on site, or payable on presentment at no time for payment stated. I'm sorry, if there's no time stated on it, then it's automatically a demand. Okay, so we can have demand on site. We talked about on site, that's 30 days from when it's presented. It could say, like a check, the date, it's demand. The check is also presentment when it's presented. And if there is no time stated, it's automatically deemed a demand. Okay? So definite time, fixed period, a certain date. What do I mean by all that? Some further examples. A fixed period after site, that was in our draft, 30 days after April 20th, 2020. Could have a certain date. Payable on April 20th, 2019. It can have a certain date subject to acceleration. We talked about acceleration when we had the mortgage. If you didn't pay on time, it could be accelerated if you didn't pay on the due date. You can have a certain date subject to extension. It's payable on April 20th, 2019 with the option of the person who is holding it asking for the extension. So for example, do I have it here? Yep. So for example, a note that states I promise to pay the order of Will Smith $1,000 on May 15th, 2020, but if I lose my job, payment will be made on August 15th, 2020. That is valid because you can ascertain the dates, right? If you know that if the person loses their job, the payment will be, their payment would be August 15th, 2020, not May 15th, 2020. So an instrument that contains a clause stating that it is payable 10 days after drawer obtains a bank loan. This would not be deemed negotiable. Why? Because it's an unknown when or even if the drawer is going to obtain a loan. So this does not give us the ability to ascertain a definite date. An instrument that's dated February 1st, 2018, 1 year after the death of my grandfather, James Jones, I promised to pay to the order of Henry Hertz $500 and signed to Mary. Is this negotiable? No, because number one, we don't know when the grandfather is going to die, if he's still alive. But what if he did? Is it negotiable? No, because it doesn't say a time for payment. So, definite time. So our last element for a negotiable instrument, payable to the order or bearer, with the exception of checks. Negotiable instruments must be paid to the order of or to the bearer of. Checks are excluded because basically it's good policy to treat as a negotiable instrument regardless of that language, because they're usually on pre-printed forms. They're so common to have checks. They're on forms, and it's usually the language is on the forms, but sometimes it just can be overlooked. And also, what are checks used for? Payment. But what else could they not be used for? Right? You're paying somebody and you're using a check. That's what they're used for. So they're kind of treated as the exception. They have some other exceptions we're going to talk about. So you don't need this language if we're dealing with a check. So we have order instruments. Paid to the order of, and then they ID a person, Rebecca Fox. Paid to the order of Rebecca Fox. So this can be any persons together, Don and Judy Williams, or an entity, Fox Law Office. It has to specify exactly who the instrument is going to. That's called an order instrument. When you see a specific person on it, you know it's an order instrument, paid to the order of. Then we have bearer, order to bearer instruments. They don't have to specify a person, a specific payee. The maker or drawer agrees to pay anyone who presents the instrument for payment. So it can say payable to the order of bearer. It could say payable to bearer. It could say payable to cash. It could say pay to the order of cash. Any combination of those. That's usually what it's presented as. And the idea is anybody who is holding that document is entitled to the payment on it. We're going to talk about, and you could probably see already that problems can arise with that. We're certainly going to talk about problems that will arise with instruments that just say payable to cash and payable to bearer. So missing or ambiguous terms, will that destroy negotiability? Depends on what it is. But like I said, it would destroy negotiability. It doesn't say that it destroys the document or invalidates the documents. You just become the assignee in it, and it works like how we were talking about under contracts. So we have the assignment aspect. I always like to hit that home because I don't want you to feel like, oh, then this doesn't work. This isn't an instrument that's valid. Don't want you to think that. That just means it doesn't transfer with superior rights. And we're going to get down that avenue in a second. We're just working through these piece by piece. So omissions or being incomplete. If there's an omission of a date, it does not necessarily destroy the negotiability unless the date is necessary to determine when it's payable. So a check that is noted or dated, it's still negotiable because why? A check that's not dated. Because we know that checks are demand documents. You don't need 30 days from now. We know if you got a check and they have a date on it, it's demand. A draft that is payable 30 days after its date. If the date is left off, well, that's kind of a problem because you don't know when it becomes due. Can it ever be fixed? Yeah, it can be fixed. If there's an authorized party, maybe the drawer or some other individual who knows what the date is supposed to be, if you have an authorized party who can fill in the appropriate date, and then that would make it negotiable. What if a payee's name is spelled wrong? That happens all the time. That's not a problem. Having the payee's name spelled wrong, they can either sign it with the spelled correct name or spelled with the wrong name. Some banks require the signing of both to have, but that won't take it out. Obviously, the dates usually kind of trip us up a little bit, but those are the issues relative to the dates. And the next